our goals as in-house lawyers or an in-house legal department and the goal of the law firm or the law firm lawyer are actually in direct conflict. Everybody may want to win against whoever the adversary is, but the reality is that their goal, the law firm, is to make money, and they make money by spending their time. Our goal is to spend the least amount of money possible, right, while still getting good results. So that's direct conflict right there. So my expectation is to have that trust right at the beginning, to understand these are my expectations, these are my goals, this is my budget, and these are the objectives for the piece of litigation or the advice that I'm seeking, and to be able to have that open communication so that when a conflict does arise between the law firm and the in-house legal department, you can have a conversation about it.
Welcome to On Record PR. I'm your host, Gina Rubel. Today, I'm going on record with Sabrina Mizrachi, who is the Vice President and Deputy General Counsel of Litigation and Global Product Regulatory at Estée Lauder. She provides regulatory guidance, manages a comprehensive litigation portfolio, and protects the company's brand integrity on a global level. Welcome to the show, Sabrina.
Thank you so much for having me.
So what fun. Before we started recording, we learned that we both practice law in Philadelphia and that we're both mothers of children who were born in this region, but you're now working in New York. So much fun. I can't wait to dig in. For our listeners, I had the pleasure to listen to you speak at the Women's Conference it's called WIPL, W-I-P-L, by ALM in 2003, and we were all in New Orleans. And you were a panelist during the session on hot topics in litigation. So we're going to talk a little bit about that and the litigation landscape, and we're also going to talk a little bit about social media, and how that plays out in litigation as well. So without further ado, because the listeners are here to hear from you, what are some of the most significant changes you've experienced in the litigation landscape in recent years, and particularly as there's been a shift to remote depositions and hearings?
So I think everybody's pretty tired of hearing about COVID now, and that's a good thing. But I think that the biggest shift that we've seen in the past, let's say 4 to 5 years, is that in the time period where the courts were closed and people were not in person doing anything, there was a very, very strong increase in the number of cases that were filed or investigated and then filed or investigated and then threatened. And so I think not just for our company, but industry-wide in different industries, there's just more, right? There's just this period of time where plaintiffs sat around and had extra bandwidth and found new ways to use the system to advance the wants or the needs of their clients. And once we got back into the world, it wasn't complete, but we have this great technology which allows us to have hearings and, in fact, even trials in a remote way. So we got back to depositions, we got back to status conferences, we got back to hearings and eventually trials by Zoom, with this increased amount of litigation out there in all different areas, a couple of which I think are new areas of litigation that we haven't really seen too much in the past.
What are some of those?
I think there's been an increase in privacy actions. There are some statutes around the country, regulations that require certain disclaimers when you use a technology online, which was a very big thing during the pandemic, like a virtual try-on technology, for instance, for cosmetics, where you can look at the lipstick color or hairstyles or blushes or whatever it may be. And there are some very arcane regulations out there that have requirements when you do that sometimes may or may not have been met. So that has opened up a new area for litigation in that privacy space.
Oh, that's fascinating. And as a user of your products, I find it amazing because I love those things. I love to be able to see, what is this going to look like on me, on my skin tone and things like that. So it's fascinating as a former litigator myself to see where these things go along the way. So what are some of the challenges with remote depositions and hearings?
So I think there's some procedural challenges, like just with the technology itself and getting used to it and feeling comfortable in those situations. And I have some funny stories about things that have happened that have been kind of problematic, which I'm happy to share. But I think the biggest part of the challenge is that you don't have the ability to be in the same room with your either adversaries or co-counsel or clients or the judge or mediator or the court reporter. And so while a lot of in-house lawyers talk about how much money they save and not having to fly people around the country, there's a downside to it, which is not developing those relationships, not having relationships either with your adversaries or co-defendants of trust, talking about their kids or whatever the case may be, so that you can develop that in a way to make the litigation itself really less adversarial and conflictive, which is better for everybody. Work out the problems, avoid motion practices, maybe mediate in a way that when you know you have to leave to get on a plane or in a car or home for dinner, you're going to push to get it done as opposed to getting back on the phone the next day on another Zoom and sitting around for hours doing it that way. I think that there's a motivation that comes from being in person and also a human aspect to it that we can't do on a Zoom.
That's so interesting. I originally was just thinking about not being able to see body language or when opposing counsel was writing notes, or if you're in a jury trial, the way people nod or smile or shake their heads. But I didn't think about, we used to use time to our advantage, right? The day was ending, you were running out of the courtroom, and time is money. And can we get this settled today? The courtroom steps settlement, as you will. I never really thought of that because I no longer litigate. So that's really a fascinating point that you make. So how do you use these tools to your advantage?
So, there's a cost savings to it. If you already have a relationship and you need to schedule something like an expert deposition or something like that, you can use that to your advantage. It does create a lot of efficiencies for us, both financially and physically, just not having to be on the road and on a plane and away as much. If you have the flexibility to pick and choose in those circumstances. I also think that sometimes when things are tough, whether it be a mediation or a negotiation or deposition, like a sick plaintiff in an injury type of case, right? It gives you the opportunity to allow the plaintiff to have his or her time to be deposed. It allows the defense to have their time to depose the plaintiff without being sort of invasive into their home or their hospital or something like that. I mean, most big companies have these personal injury type cases come up, and it can be emotionally difficult for everyone involved. And so kind of having that screen, the camera, instead of being in person, can give the participants a little bit more grace and dignity. And I think that's helpful.
So I wasn't planning to ask this, but because you manage the litigation portfolio now and are no longer the one litigating, as you mentioned before we started recording, I'm curious about your expectations of outside counsel. What do you expect of them? How do you want them to show up? And what makes them most valuable to you?
I think it's the partnership, right? So I have spent the past 13 years thinking about this since I went in-house. And, our goals as in-house lawyers or an in-house legal department and the goal of the law firm or the law firm lawyer are actually in direct conflict. Everybody may want to win against whoever the adversary is, but the reality is that their goal, the law firm, is to make money, and they make money by spending their time. Our goal is to spend the least amount of money possible, right, while still getting good results. So that's direct conflict right there. So my expectation is to have that trust right at the beginning, to understand these are my expectations, these are my goals, this is my budget, and these are the objectives for the piece of litigation or the advice that I'm seeking, and to be able to have that open communication so that when a conflict does arise between the law firm and the in-house legal department, you can have a conversation about it, or you can say, you did something that didn't meet my expectation. Can you do it a different way? It's like an adult to adult communication as opposed to a parent-child communication where it's disciplinarian or, I'm talking to you because you're not as mature as I am. And so that partnership is really the most important thing of all.
I couldn't agree more. We're going to take a quick pause for a message from our sponsor, and then we'll come back with a few more questions.
This episode is brought to you by Gina Rubel Communications, a public relations and marketing agency serving law firms and businesses internationally. With an expert team of professionals positioned throughout the U.S. and supported by international affiliates, Furia Rubel enhances its clients' brands through integrated communications by providing expert guidance in crisis management and high-profile litigation, protecting brand and reputation, and supporting internal marketing teams with media relations, media and crisis training, and client and talent acquisition and retention. To learn more, visit furiarubel.com.
Welcome back, everyone. This is On Record PR, and I'm talking to Sabrina Mizrachi. She is the Vice President and Deputy General Counsel of Litigation and Global Product Regulatory at Estée Lauder. And so we're going to turn the conversation a little bit now, and we're going to talk about the influence of media and social media on litigation. So I'm curious, how have you seen the uses of these platforms impact the perception and dynamics of legal matters at Estée Lauder?
I think the biggest way that happens, and there may be a lot of small ways, is that, if you're going to participate in a jury trial, you can pretty much be sure that at least half, if not most, of your jurors will have seen something about the issue in social media or in the media. I mean, information is so available at this point in time that, you're getting news alerts on your phones, you're scrolling through Instagram, there's lots of ads, and there's just a lot of noise around sort of the big, sexy. There was recently a verdict in a Philadelphia court where you are that was over $2 billion against one company for one person. And most people will have heard about that because it's about a product that's out there in the world that's very visible. There's a lot of stuff about baby powder. There's a lot of stuff about other kind of cancers in California with Prop 65. And so because it comes up on social media with, one, people's opinions, which now are kind of free to put out there in the world, two, advertisements, and three, just access to news. And so when you have a pool of jurors come into a courtroom, they're very likely to have seen something about your issue if it's a big enough issue. And so that means that their opinion is probably predetermined or at least leaning one way or the other before they even hear anything about the evidence. And so I think that social media makes it very difficult to have an unbiased juror. And that's the way I see it the most. And, it makes it harder to defend yourself when the court of public opinion is already kind of biased against you.
So how do you manage the media, like the real reporters? I say it that way because there's a lot of people who think they're reporting, citizen journalism. But how do you handle the media, or do you have policies around media as it relates to litigation?
So for all of the companies I've ever worked for and all the clients I ever worked for when I was outside counsel, there's always been the policy of we do not comment on active litigation. And so we just don't do it, right? We don't comment on a pending case. I've had verdicts and resolutions in the past where we have, companies that I've worked for, not this one, have commented post-verdict on something. But I find it, and I don't have a good answer for this because I don't see a way for us to have that influence as defendants in industry that's currently selling products to consumers to take a position on these things. It's so delicate and it's so sensitive. And all we can say is we don't comment on it, or we're defending the case, something like that. And it's so generic that if you really think about human beings, they're not comforted by that. And so the answer is I don't have a good answer. We don't really know what to do other than to be as honest but quiet about a conflict as possible.
Well, and really, if you think about the rules of professional conduct, Rule 3.6 says you shouldn't try your matter in the media anyway. So what we always tell clients is defer to Rule 3.6. Under the rules of ethics, we can't try our case in the court of public opinion. So we're not going to share anything until after litigation. And then we might not share anything then either.
Right.
That's a perfect answer, by the way. So
I love being told that my answer is perfect when I've said I don't know.
But that's integrity. And Sabrina, that's exactly what the media needs, is people with integrity. So to say, this is just not something we're able to speak about, we're trying it in the court of law, is a very perfect thing to say when the firm has a policy against it, or the company. So that's why I say it's perfect. Given the ongoing evolution of technology and media trends, what advice do you have for the legal professionals out there or outside attorneys who are looking to stay ahead of the curve, effectively navigate the landscape, especially in litigation? Or do you?
It's another one where I'm just not really sure. I just don't know what the right answer is there, because I think it can go in different directions. And, you may have seen that from your point of view as you were an active litigator before, but you're still dealing in litigation now, that it's hard to have uncertainty when it comes to these kind of things.
Well, and what's so fascinating to me, and I did not practice in the age of social media. It was a very different landscape. And, we had very specific tools that we used to read the media, but it wasn't being shared online. There was no such thing, right? So are you in-house keeping an eye on what people are saying on social media and in the media, or do you expect your outside counsel to do that? Or does it depend on the situation?
Yeah, I think it's both, right? So I have a Google alert, multiple Google alerts in my own Gmail account. We also have a, large communications department, and they alert us to things that may be relevant to active litigation or threatened litigation, that sort of thing. But for whatever we have outside counsel assigned to, we would also expect them to do it. So, we recently settled an ERISA case that was in the media, and it came up on my Google alert. I got it from my in-house communications people, and the outside law firm sent it to me. So it's very low risk that I'm not going to see something that's relevant to the company when it comes to litigation.
But again, what I'm hearing is we're keeping our eye on it from every perspective. And in that case, your outside counsel did their job, because they need to keep an eye on it. And oftentimes it's like, oh, it's over. We're done now. Move on. So again, knowing that outside counsel is keeping an eye on the court of public opinion to best serve you as a client without overbilling or getting into that conflict of who's doing what. I think that's really important. I mentioned to you earlier that I was going to ask about generative AI, and you shared that that's not really part of what you do. I'm curious about, are you aware of any ways that Estée Lauder is using generative AI to further its brand by chance, or is that just something you wouldn't be aware of?
I know that they're working on it. And I know that there are some things happening in sort of like the online function, like our digital people, our tech people. In legal, I'm not working on any of that right now, but I know that it's happening around me. And I do think it's something that people are absolutely going to have to pay attention to, because it is out there.
If a law firm could use generative AI in a safe way to cut down their costs, is that something you would want them to do, and for you to be able to test to make sure it's right for your company?
So I'm very open-minded about things, especially that relate to cost savings, because obviously one of my objectives is to keep our costs down. I just think that there are a lot of caveats to that. I'm sort of right at that age where I'm skeptical about technology, but I've lived through a lot of it. And so, I still write notes with a pencil and paper. Right. And I'm not great with technology, but I understand that the people around me are. And so I'm open-minded about it. I'm just skeptical.
Yeah, I think you and I are in the same boat there. So, I mentioned to you earlier, I started practicing law when we didn't have email yet. So, which is kind of crazy to me. I remember when my dad required me to have a cell phone because I was driving long distances on weekends, and the cell phone was in a bag that plugged into your car lighter. So,
yeah.
So,
right.
Technology.
I remember those big ones.
Right. Technology has changed, but it's also changed the way we practice law. It's changed the business of law, how we do things. And as I heard you say, it's changed relationships and strategy. So I think these are all things that our listeners are going to need to think about as they move forward in their practices. But with that, and I promised you 15 to 20 minutes, so I'm going to keep it there. So I'm going to say thank you for this great conversation, Sabrina, and to our listeners for tuning into On Record PR. Please visit our website at onrecordpr.com. Subscribe to the podcast. It's on every platform. Share it with others, and check out our show notes. If you can't listen because you're somewhere where you can't play it than read it. And as always, we welcome guests and topic ideas sent to podcast@onrecordpr.com. We will see you next time, folks.
On Record PR is produced by Jennifer Simpson-Carr and Matt Henderson, with support from the team at Gina Rubel Communications. This episode is edited by Željko Tomic of Compost Media Flow.